Okay. So welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you so much for joining us this morning. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We also record our webinars, so if you missed part of today's webinar, or if you want to go back and watch it again or find a different one, they are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll also have another slide later with more information on accessing those resources after the webinar. So if you would like to download a copy of the PowerPoint right now, I am going to share a file for you to download and save to your computer. So bear with me a moment while I share that file. Okay, you should see a pop-up window where you are able to select the file and download it to your device. If that doesn't work for you, you can also, as I mentioned, download it on the webinar page on our website at the bottom of the page under Data Practices Potpourri. All right. So today's webinar is another installment of Data Practices Potpourri, where we highlight some of the questions data requesters and government entities raised in the past month or so. We will also leave time for some Q&A at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. If you do that, make sure you choose all panelists when you send in your questions, just so that we can be sure to see them. You can start sending them now, or you can wait until the end of the presentation. All right, so our first question is about informed consent. So data classified as private data on individuals are available to the data subject as well as anyone the data subject authorizes to receive that data. So in this scenario, a data subject provided informed consent to the government entity so that their attorney could access private data about the data subject. The attorney comes back asking for private data on that data subject a year later. So how long is this informed consent from the data subject good for? So the Data Practices Act does not specify how long informed consent to access data is valid. So the government entity has discretion here to determine whether informed consent from a subject is still valid. For practical considerations, we do suggest having an expiration date on any informed consents you receive, or if you use a standardized release form, including an expiration date field there. The data subject may have also indicated on their informed consent an expiration date, so you can check for that as well. If you do not have expiration dates, you'll have to manage all these forms and make determinations as the situation arises. Another consideration here is that the data subject must have sufficient mental capacity to understand the consequences of giving consent. So with that in mind, data subjects cannot provide informed consent for data that does not yet exist, since they can't understand the consequences of consent to data that have not yet been created. So Advisory Opinion 99-010 from the Commissioner of Administration discusses this analysis. So for this situation here, the attorney may not have access to data created after the informed consent was provided, and the entity has discretion to determine whether the previous informed consent is still valid and whether the attorney may access the older data. Another question we've seen recently is when data requesters refuse to provide a name or address when requesting data from you. So how can you process this request? First, a reminder that Minnesota Statute Section 1305, Subdivision 12 states that data requesters are not required to provide a name when requesting data. Under the Data Practices Act, they do have a right to submit anonymous requests when requesting public data. So while requesters are not required to provide this information, On your request form, you may wish to provide for some optional fields such as email or phone number so that you can coordinate providing access to the data when the request is filled. You can communicate this information. You can communicate this information is used to inform the requester when the request is filled, and then the requester can determine whether to provide this information to you. And if you do not already, consider what to do if a requester does not provide any contact information and does not contact you again to coordinate receiving the data. So what are your procedures and policies to determine when a request is abandoned? And finally, just a note that if the requester is asking for data classified as private data on an individual, the government entity is required to confirm the requester's identity since they are obligated to protect this data and only release it to the data subject or the individuals or entities authorized by the data subject. So the entity has discretion as to how they confirm identity then. So if you would like an example, our model policy for data subjects, which is available on our website, includes a list of possible methods to confirm identity. For our next question, a member of the public contacted a government entity asking for all complaints on a specific employee. So what data on complaints can this government entity release? So the answer to this will depend on the status of any personnel investigations and discipline related to the complaint and the identity of the complainant. So first, if the employee is not considered a public official and the complaint did not result in disciplinary action, or if the entity is still investigating the complaint, then only the existence and status of the complaint are public data. And this is because data about employees, which are classified in Minnesota Statutes 13.43, are presumed private unless explicitly classified as public. So this is the reverse from all other government data, which are presumed public. So here, the data are private, and only the existence and status of complaints are classified as public under Minnesota Statute Section 1343, Subdivision 2A4. So any other data, even such as even general information about the nature of the complaint, is not public. And I've cited a case here in Navarre versus South Washington County Schools that does discuss this. But if this complaint led to a disciplinary action, then different data are public. So under Minnesota Statute Section 1343, Subdivision 2A5, if there was discipline, the final disposition of any disciplinary action, along with the specific reasons for the action and data documenting the basis of the action, will be public. So if there is final discipline resulting from a complaint, data in that complaint are likely part of the reasons for the action or the data documenting the basis of the action and would be available to the requester. And this analysis applies to employees who are not considered public officials under Minnesota Statutes 1343, Subdivision 2E. So if you think you are working with data about a public official, feel free to contact us to discuss. We also offer an all-day workshop on personnel data that dives deeper into employee disciplinary data. And just a final note, one question we see a lot with employee complaints is whether to redact the name of the complainant or their identifying information. So if the complainant is a government employee, data identifying the complainant will be private personnel data about the complainant and need redaction. So this is from Minnesota Statutes Section 1343, Subdivision 2A5. But if the complainant is a member of the public, then their identity is just public. So Demers versus City of Minneapolis, which is cited here, discusses these private and public complainant identities. We've had a lot of requests to address vulnerable adult data in our potpourri, so I'm going to highlight one situation we see frequently. So here, a member of the public requests a case file from a law enforcement agency. The case is inactive, but it involves possible maltreatment of a vulnerable adult. So what data can the public requester access? So we're talking about law enforcement data here, so we turn to Minnesota Statute Section 1382. Subdivision 7 states that if the criminal investigative data are inactive, they are public. But because this case involves a vulnerable adult, you need to look at 1382 subdivisions 10 and 11 as well. So subdivision 10 classifies identifying information on the victim and the reporter of maltreatment as private. So any data identifying those two individuals would need redaction. Subdivision 11 classifies some of the investigative data as private depending on how the case became inactive. So if the case is inactive because the prosecutor did not press charges, or because the statute of limitations ran, or the offense is over 30 years old, then data related to any alleged maltreatment of a vulnerable adult by a caregiver, or facility are classified as private. So these requests can be difficult. You'll first need to determine whether the data are about vulnerable adult maltreatment as defined in Minnesota Statute Section 626557. And if they are, we'll need to redact identifying information on the victim and reporter. Then you'll need to determine how this case became inactive, and if it became inactive under Minnesota Statute Section 1382, subdivision 7A or B, additional data will need redaction if you determine those data are related to alleged maltreatment by a caregiver or facility. So as you work through these requests, please feel free to reach out and contact our office to discuss these requirements. We've had government entities reach out to us concerned about letting requesters come into their offices and browse their records. Some requesters want to come in for an inspection and browse the records or search the records requested. The entity wishes to provide for inspection of data by making copies of the data available in an office for the requester to view. So do entities have to allow members of the public to come in and view these original records? So the right to inspect data is discussed in Minnesota Statute Section 1303, Subdivision 3. So here the statute notes that requesters may inspect government data, quote, at reasonable times and places. So this means you as an entity have to determine whether the scope of a particular inspection request is reasonable. And while you are obligated to provide the data for inspection, you're not obligated to honor requesters' conditions if the access conflicts with your own policies and procedures. And keep in mind, entities have obligations under which may prohibit access to original data. So for example, under Minnesota Statute Section 1305, Subdivision 5, entities must protect not public data so that only authorized staff may access the data. They cannot permit requesters to browse this data without redactions, or they would not be protecting this data as is required by the statute. And even if your data are public, you still have obligations to ensure your records are easily accessible for convenient use. To ensure your records are properly managed and organized to meet the statutory requirement, you may require only staff access originals and search for the data. And this aligns as well with any record management obligations under the Official Records Act and Records Management Statute. But please note, our office does not advise on official records or record keeping. So if you have questions, you may wish to speak with your records manager if you have one, or to contact the Minnesota State Archives at the Historical Society. And I just listed a bunch of reasons why you may protect access to your data, but I also want to note that under the Data Practices Act, requesters are entitled to access actual data. You can't say, copy and paste public data elements from a document into a new document. The requester is entitled to see the data as it is with redaction. So Advisory Opinion 12-009 listed here discusses these obligations a bit further. Our next question is regarding traffic accident reports. So many law enforcement agencies have state traffic accident reports, which they must submit to the Department of Public Safety. They then receive requests for these traffic accident reports from members of the public, including private companies. So can these public requesters get a copy of these traffic accident reports? So you must provide access to public data, but what data you provide will depend on the data that you maintain. So first, let's talk about the state accident reports. So access to the state traffic accident report is governed by Minnesota Statute Section 16909. So subdivision 13 of this section prohibits sharing of the state traffic accident report except to parties listed in this statute. And members of the public, which include private companies that are not affiliated or authorized by the data subjects, are not one of the parties listed that may see that report. However, note that 169.16909 subdivision 13 states subdivision D, excuse me, states that releasing data on the state traffic report that aligns with the request for service data that's listed out in 1382 subdivision 3 or response or incident data elements that are listed in 1382 subdivision 6 is not a misdemeanor. So because of those provisions in 16909, what data the law enforcement entity provides will depend on the data they maintain. So if law enforcement keeps their own traffic accident report, they must provide that in response to the data request. If law enforcement does not have their own traffic accident report and they only maintain the state traffic accident report, they must provide that report with redactions so that the requester only receives data elements matching those listed in 1382 subdivisions 3 and 6. And just a note, here in this scenario, we have a for-profit company requesting data. The entity should provide the public data, which will vary, right, depending on the entity's data, as we've just discussed, but entities cannot withhold data because they object to the potential use of public data. Requesters have the right to use the public data as they like. And I've cited Advisory Opinion 98-049, which discusses these considerations. All right, our final question here is a frequently asked question. It's one we're always happy to get, which is requests for specific training or webinars from our office. And I've included this question as more of a shameless plug, right? We have recorded many trainings on these topics and posted them on our YouTube page. So I encourage you to visit and see if there is a recorded training available on the subject that you need. And if you haven't already, please consider signing up for our newsletter, which will always contain notices on future trainings and topics. And our website also includes training materials under the resources section. And there is a form under our events page to request a training. But of course, if you need assistance finding one of these videos or if you want to discuss a training, I hope that you will reach out to our office to discuss. Okay, so those are our questions for today, and we are looking forward to taking a look at some of yours. If you haven't already sent your question in, if you'd like to ask a question, please remember to send them to all panelists so that we can be sure to see them. And while my colleagues are looking at those, just a few reminders on this slide. The slide deck is available on our website, and you can access the recording of this webinar on our YouTube page in the next day or two. In just a moment, I'm also going to put up an evaluation in the polling panel on the right-hand side of your WebEx screen. If you could take a moment to fill that out, let us know how we did, give any feedback. We want to make sure that these webinars are useful to you and covering what you need. So we would really appreciate any feedback that you can provide. So with that said, I am going to open the poll. And you should be able to provide some feedback now. In just a moment, and myself and my colleagues will take a look at your questions and begin answering them. Thank you.
Okay, let's start with our first question for today. The question is, what mental health data can be released and to whom? So the answer to this question is it will depend on how you've collected the mental health data and who it's about. If you are working for a law enforcement agency, the first thing to ask yourself is if there's a protected identity involved in subdivision 17. Any identifying information on protected identities in subdivision 17 will automatically be protected. One of those protected identities is the caller, the identity of a caller in a mental health emergency, which isn't necessarily the individual who's experiencing that mental health crisis. And so you'll have to take a look at that situation to determine whether one of those protected identities is applicable. Another situation in which you'd protect certain mental health data is if the mental health data is covered under one of the sharing provisions under 13.46 to law enforcement. There's one sharing there where certain community mental health providers when they share certain mental health data to a law enforcement agency, that data retains specific protections, and the individual who the data are collected about are entitled to be aware that that data was collected about them. The last exception or protection that mental health data might have is if you obtained the data directly from a healthcare provider. In Minnesota, we have what's called the Minnesota Health Records Act, which protects data that are obtained directly from a healthcare provider, and that data cannot be redisclosed without specific statutory authority or written informed consent from the individual who the health records are about. However, if none of those exceptions apply, there's no other classification for this data, and you just happen to have mental health information about somebody that reached out to law enforcement. Maybe there was just call for service data that mentions that this person has some sort of mental health crisis in the past. There is not a general classification for that at this time. So you would need to look for one of those particular exceptions. If you do encounter mental health data when you're responding to a data request and you're not certain whether one of those exceptions applies, you can always give us a call, and we're happy to walk through those different options with you.
Okay, we've got a question here where there is, I'm guessing a municipal fire department is considering implementing body cameras for fire incidents and investigations. EMS will not be part of that, so the paramedics are not going to be wearing these body cameras, it appears. The question is, does section 13.825, which governs portable recording systems or body cameras, in any way apply to the fire department's use of body cameras, or does the entity have the authority to develop their own policies? And then also some questions about whether there's been talk about other fire departments or response agencies using body-worn cameras, and if the legislature is intending to start regulating their use outside of law enforcement. So a lot going on in this one. But when it comes to fire departments or other types of maybe first responders wearing body cameras or using body cameras, so paramedics, maybe security guards, or other sorts of non-licensed peace officers, essentially, 13.825 does not apply, or probably does not apply. Specifically, when you're looking at section 13.825, under subdivision 1, the definition of portable recording system means a device worn by a peace officer that is capable of video and audio recording of the officer's activities and interactions with with others. So, that use of peace officers term there, it's not defined within section 13.825, but I think it's reasonable to interpret that as a licensed peace officer. And so an officer that's licensed by the POST, the Peace Officer Standards and Trainings Board, and so a licensed peace officer, or kind of a typical licensed police officer there. And so when others are wearing body cameras, whether it's a fire department, paramedics, security guard, or a non-licensed officer, I think the 13.825 requirements do not apply. What that means is that the data that are collected by those body cameras are going to just probably be presumptively public at that point, unless there's another provision that you can point to within the Data Practices Act that allows you to withhold the data. And so there may be other provisions at different times that you could point to say, hey, this classifies this video data that a fire department officer has collected. But in most situations, 13.825 would not apply to it. As for whether the legislature is considering regulating their use outside of the law enforcement context, not sure. I haven't heard a lot of discussions, and I don't think anybody else in the office here has heard a lot of discussions about that. But as body cameras are continuing to grow in use, the statute has been around for several years now at this point, and we get a lot of questions related to whether or not there's going to be some additional regulations or changes to the statute, and it may be possible. But at the moment, there's no discussion about kind of extending 13.825 to other types of first responders other than the licensed peace officers.
Okay, the next question we have here. If a request comes in and your organization has responsive data, but also knows of a better source of that data, is it appropriate or permissible to provide the public data that is responsive and let the requester know where else they could reach out for such data? Yes, absolutely. So the Data Practices Act doesn't address these sorts of situations. Under the Data Practices Act, you are required to provide the responsive data to the request that comes in. So if a requester contacts you, you have responsive data, your entity is obligated to provide that data. But as part of your customer service or your internal procedures, if you know of other places that the data are available, you can definitely chat with that requester, point them in a different direction. But if they still want to come in and see the responsive data that you have, you would also have to provide that.
We received another question. Do you have any recommendations around granting free copies to certain groups, such as media or other government officials? So the Data Practices Act has a copy cost structure, but that copy cost structure is not required. So every government entity can decide its own policies and procedures whether to charge at all for government data. And generally what we'd say as a best practice is to be consistent. Have a threshold in your policies or have some sort of determination or mechanism to determine when it is you are or are not going to be charging for copies, so that when a request comes in, it isn't solely up to discretion on whether you're going to charge for copies based on who it is that is requesting. Maybe it's the type of data, maybe it's whether the request reaches a certain amount, such as $50 or $100. But that is up to the government entity that's providing access to the data to determine when and if they will charge for those copies.
Okay, got another body camera question here, and this one maybe is a little bit more broad because we can talk about redacting, but for body-worn camera, when redacting a protected identity, is it sufficient to just redact the face, or should the whole body be redacted? This is a great question, and as oftentimes with data practices, it really depends, and redaction really is more of an art than a science, and redaction can be more than just a name, someone's face, an address. It can be whatever identifying information is about that person. And especially when we're talking about protected identities, the obligation is to protect that identity. So it might definitely be more than a face, but it really depends on a case by case basis. And so if somebody's wearing something that is particularly identifying, it's the Hawaiian shirt person that everybody knows in town. You may want to redact the entire body in that situation. If someone's just simply wearing a red sweatshirt and there's no other identifying information with that, that may be, a situation where you don't have to actually redact, the entire image of the person. But really, it's going to be your judgment call on that and thinking about the context of whether or not you'll be able to identify that person based on what you can see of their image. And so really it is, thinking about protecting the whole identity rather than just maybe the face. And so it's going to be a case-by-case basis, and we would leave that to a judgment call as you are going through that redaction process.
We have another question that came in. One of our regular data requesters used to receive electronic copies of data at no charge. We are now charging for them based on the copy cost structure, but they're arguing that they shouldn't be charged because they've never been charged before. We can move forward with charging, correct? Yes, so you are legally entitled under the Data Practices Act to charge for copies. If you have a history of not charging with them, that might have set expectations for not charging in the future, but each new request can be treated differently. I would just ensure that you're following whatever policies and procedures that you have in place, and then point them to your access policies to show that you're following your charging protocol. And then if you have any additional questions about communicating that to them or discussing those requirements, you can always call us directly or direct them to our office as well.
All right, thank you everyone for your time and your questions and your feedback. We greatly appreciate it. Yes, as Katie mentioned, if anything else comes up, please feel free to reach out to our office. Our contact information is available on the website. As I mentioned, this recording of this webinar will be up on our YouTube page in a day or two. So please check back for our YouTube page as well. If you're not already signed up for our newsletter, notices for our upcoming webinars and workshops will be going out shortly. So thank you so much for joining us this morning and have a great day.